Good evening, gentlemen. I'm sure we all had quite an awesome and lovely day. All right, you're welcome to tonight's online session. I still remain your host, O.O. Stevens. And today we are going to be looking at the topic Wills and Codicils I. Wills and Codicils I in property law practice. First of all, what is the meaning of a will? In a layman's understanding, a will just means somebody expressing his wish on how he intends his property to be disposed upon his death. For instance, if a man who is in anticipation that is no longer getting young, and he knows that he has properties scattered all over the globe, and he intends to give those properties to his children and some other dependents and other people that he may wish to be in possession of the property upon his death, and he wants to have it in writing, or he wants to have it penned down. If he has those wishes of his on who he wants to take what to be penned down or to be in a manner that is ascertainable upon his death, such is called a will. Such is called a will. So it is worthy of note that will is only effective upon the death of a person. And when we say that it is effective upon the death of a person, that means we are saying that it is testamentary. It is testamentary. So the effect of a will is only obtained when the person who has made the will dies. Now, the person who makes a will is called a testator. The person who makes a will is called a testator. And if a man makes a will before he dies, he will be said to have died testate. He will be said to have died testate. But if a man doesn't make a will before his death, he will be said to have died intestate. And there could be instances where he probably made a will, but the will is not in consonance with what is expected of a valid will. He will also be said to have died intestate. We will still get to that and appreciate what we mean by somebody making a will, but the will does not actually meet the requirements of a will. So should be said to have died, that he has died intestate. So where a man makes a will, he is going to appoint people that are expected to dispose of that his property when he dies. Those people are known as executors. Those people are known as executors. Now, the people that he gives the will to are known as beneficiaries. The people that he gives the gifts to, the properties, the people that he disposed them to are known as beneficiaries. So it is worthy that we appreciate the concept of what is a will, who is a testator, who is a beneficiary, who is an executor. It is very, very important. But where a man dies intestate, the people that end up executing or disposing of his property are known as administrators. Now, administrators are appointed by the court, while executors are appointed by the testator. So it is the court that will appoint administrators, but it is the testator that appoints executors. Now, when we get to the topic on legal representatives, we are going to appreciate the difference between an administrator and an executor and the effect of each of their various powers. Now, what are the characteristics of a will? What are the characteristics of a will? A will is testamentary, means it comes into effect upon the death of the testator. A will is also revocable. A will is also revocable. Revocable means that the person who made the will, so long as he's still alive, can choose to alter the will to either contain a particular wish that he has. A will also has to be executed. It has to be signed by the testator. And a will must also be voluntary, meaning there shouldn't be any likelihood of a gun was pointing on your head or you were suffering from any undue influence while making the will. Such will not be said that you made the will from your heart. And also there has to be a disposition of gift. So what makes a will is that gifts were disposed, is that gifts were given out to individuals in such a way. Now, what are the advantages of a will? This is an exam area. What are the advantages of a will? One is that a will excludes the rule of inheritance. A will excludes the rule of inheritance. So by a will, you are going to be telling this person that he's the one that has this, he's the one that has this. So assuming there is any customary right that has said that this thing ordinarily goes to this person, then once you make a will and give it out to the person, it is going to bind. However, there are some properties known as inalienable property. There are some properties known as inalienable property. So you cannot, by way of a will, dispose of such a property. For instance, the place that a man lived before his death is often owned by the first son, by the custom of Bini people, Bini custom, and it is contained in the case of Idehen versus Idehen. So the place that a man lived upon his death is called Igiobe in the Bini custom. So such cannot be disposed by way of a will, because such a property is known as inalienable property. For instance, some of the communities that still worship shrine are often presumed to be the prerogative of going. If your father was a native doctor, if he dies, the first son becomes the person following him. Or for instance, for some communities that practice what is known as primogenitor rule, which is when a king dies, his first son will become the king. If the first son dies, the son of the person. So such an instance now, you cannot be able to use by way of your will and now give the throne to your second son. Such will not be allowed. For instance, the Queen of Britain, if she dies now, her first son, which is known as Prince Charles, is going to become the King of Britain. So her second son cannot become the king. Even if when she was sick, it was her second son that was taking care of her, and the first son was nowhere to be found. The custom has already said that that particular seat is inalienable. It goes only to a particular person, and that particular person must be the person that you must give it to. That is called inalienable property. You cannot alienate it. The next advantage of a will is that it excludes the application of statutory rule of inheritance. For instance, when a person dies, there are some things that the law has said that is going to be done when such a person dies. So if you make a will, it is going to, even if it is contrary to that thing that the law has said, so long as it is your intention that you communicated so long as it is your intention that you communicated in that particular way, it is going to have effect. The next advantage is that the testator appoints the people that he wishes to execute his will for him. Maybe people that he believes have integrity, so his wishes will be respected, because by making a will, you are deciding to say, okay, it is this person that I want to execute the will. But because remember, we said that if the person died without making a will, it is the court that will appoint. But if he makes a will, then he may appoint the people he wants to execute his will or to carry out his wishes for him. The next advantage is that the wishes of the person will not be carried out. Meaning, if he wants his car to be given to his first daughter, it will be given. If he wants his house in social place to be given to his second son, it will be given. So his wishes will now be respected. Unlike when he died without making a will, it is going to be in accordance with what the administrators want and what they don't want. Now, a testator can also, by his will, appoint a guardian for his children who are minors. His children who are minors, a guardian can be appointed for his children who are minors. So if his child is not yet an adult, guardian can be appointed to hold those particular properties in trust for such a minor until he becomes an adult. And also, if a will is made upon the death of the last executor, the executor of the last executor can continue executing the will of that testator. What are we talking about? Assuming A appointed B as his executor, C as his executor. Then if B dies and C, being the only executor remaining, can still execute that will. But the situation whereby C now dies, now C himself also has his own properties, and C appointed maybe D as his executor. So the executor of that C, which is D, will be executing both the property of C and the property of A. You know that A was the one that appointed C ab initio. So he will now be executing both the property of C, who is the person that appointed him, and will also be executing the property of A, who appointed C before C died. So there is no break in the chain of executorship when there is a will. But if it is that the person died intestate and the last administrator dies, there will be a need for you to apply for another new letters of administration. When we get to the topic on probate, we are going to appreciate what is called grant of probate and letter of administration. Now let us briefly look at the types of will. Let's briefly look at the types of will. We have statutory will. Statutory will are wills that are made in accordance with the provisions of the Wills Act, and it has the following features. It must be in writing. It must be attested to by at least 2 witnesses that are present at the same time in the presence of the testator. It must be duly executed by the testator in the presence of those 2 witnesses, and the testator must have testamentary capacity and intention. So the testator must be both of age, and he must also have the state of mind to make it. So the testamentary capacity now, or the statutory age of a testator, is 18 in Lagos and 21 nationwide. The statutory age of a person that can make a will is 18 in Lagos and 21 nationwide. So the Wills Law of Lagos State states has 18 years as the statutory age of making a will, but the Wills Act, which is of general application in the nation, has 21 years as the statutory age of making a will. Now we have what is known as non-cooperative will. This is a type of will that is often made orally by a person who is in anticipation of death. This is often known as deathbed will. For instance, if a man is already dying, or they told him that he has prostate cancer and he may not live up until next week, and he remember that he has not made his will, he can be on his deathbed there and make wishes on how his property will be disposed, and such will be given validity so long as he does it in the presence of 2 credible witnesses. Now we have what is known as privileged will. This privileged will is a bit of an exception to the principle of statutory will, meaning it is a type of will that is made by persons who may really not be of statutory age. Persons who may really be minors can make a privileged will, and this privileged will is often made by those who are in the military. Somebody that is maybe of 16 years may join military, and he might have, that their life, as the person is living that morning, he is not guaranteed of the fact that he is coming back alive because of how risky their job is. So the law allows such a person to dispose of his property, assuming he already has any. Maybe his salary that he has not touched should be given to his mother. And some of them get married early though, so maybe should be given to his children or his wife, other stuff. So such is known as a privileged will, but it is for specific kind of person, but it has to be in writing, except the fact that it is most often than not made by somebody that has attained the statutory age. Now we have mutual or reciprocal will. This is a will made by 2 persons who are most often than not husband and wife. So if the husband dies before the wife will take whatever. If the wife dies before the husband will take whatever. That is known as mutual or reciprocal will. We also have what is known as holographic will. Holographic will are often wills that are handwritten. So you don't type it, and it is made by the testator alone without any witness. So there is no witness in a holographic will. It's just only the testator that makes the will, and it is often handwritten. We also have customary will. Customary will are made in accordance with the customs of the land, and most often than not, that customs are not always written. So there can be wills that are made orally, and it will still be given effect and validity. Now, it is worthy of note that an infant cannot make a will. An infant cannot make a will generally, but if it's a privileged will, it can be made by an infant. But such an infant does not have the capacity to attest to a will. So an infant cannot be a witness to a will. No, such cannot happen. So an infant cannot be a witness to a will. Also, a blind person can make a will, but a blind person cannot attest to a will. A blind person can make a will, but he cannot be a witness to a will. Now, an illiterate person can make a will, and he can also attest to a will. But when a will is made by a blind person, there has to be a blind person jurat that is attached to that particular will, meaning that you're going to let us know that the will was made by you on behalf of this blind, written by you on behalf of this blind person, and that you have read it to him and he understood what he has written. And such has to be done in the presence of a magistrate, a notary public, or a commissioner for oath. Now, when the will is made by an illiterate, you also attach what is called an illiterate jurat. Illiterate jurat is the effect that you are attaching another document stating, or you can be stating in that particular will, that this will was written by you. So you put your name on behalf of this illiterate, and that you have explained to him in social language, which is the language of the illiterate person. Please, that somebody is illiterate doesn't mean that the person is not lettered. You can be illiterate in English language, and you can be very, very much literate in Igbo language. So don't confuse illiteracy with the fact that a person is dumb. They are not the same thing. So that somebody is an illiterate doesn't mean he's dumb. So illiterate just means I don't understand this language. So I can be illiterate. Like for me now, I am illiterate when it comes to Yoruba, but I am very literate when it comes to Igbo. I am very, very literate when it comes to English language. So with respect to Yoruba language, I am an illiterate. So don't confuse illiteracy with dumbness. They are not the same thing. So once you are writing this in a language that the person doesn't understand, you need to explain to him in the language he understands, and contain it that you have explained to him and you believe that he understood the content of that particular will. After that, you need to execute that in the presence of a magistrate, a notary public, or commissioner for oath. And before a will be said to be valid, there has to be mental capacity. Mental capacity means that you have to show that the person understands what he was doing when he gave you the instruction to go and grab the will, and he also understood what he was doing when he was signing the will. When he was signing the will is when he was executing the will. And you must also show that the person is of the age. The person is of the age to be able to make such a will. Now, how do you prove that a will is valid? How do you prove that the will? So proof of validity of a will, one of the ways that a will can be proved is by presumption of regularity and due execution. For instance, if on the face of it we see that the will is in writing, we see that the will was executed by two witnesses that are present at the same time, we also see that the will was signed by the testator, the court will presume that everything was rightly done. The law will presume that the court will presume that everything was rightly done. But that is not to say that this presumption cannot be rebutted, because it is a rebuttable presumption. Rebuttable presumption means that you can show the court that despite that this will appears to be regular on the face of it, my lord, there are other things that took place. So you can lead evidence by calling witnesses to come and show that this particular will, despite it is signed by two witnesses and signed by the testator, he was doing it under gunpoint. Such can actually be led as an evidence, and the court may capitalize on it and show that this will was not actually valid. You can also lead an evidence of anyone directly affected by any disposition showing irregularity. For instance, now, if your name ordinarily should appear on the will and it didn't appear, and you can show that there is undue influence or duress on that particular man that made the will, such can actually be a basis or a ground for rebutting such a presumption of regularity. Also, you can lead an evidence of a handwriting expert to show that this is not the signature of my father. So my father is not the one who made this will, despite that there is a signature here, but this is not the signature of my father. So a handwriting expert can come and show that this particular presumption should not be upheld by the court. Now, another way of proving the validity of a will is by leading positive affirmative evidence. Leading positive affirmative evidence now means that you can bring in people to come and testify. So the evidence can be made, or there can be some things that have been written by the testator when he was alive. You can bring it as an evidence in court to show. Please, in the issue of presumption of regularity, you are not really leading any evidence to prove that. You are just showing the court the will, and the court looks at the will and believes that since everything that needs to be is present in this particular document, that means that the will is valid. That is presumption of regularity, meaning that the will is valid, meaning that the will is regular on the face of it. And we now say that that presumption is a rebuttable presumption. So somebody can wake up and rebut that thing that the court believes. So if the court looks at it and believes that it is rightly done, somebody can wake up and tell the court, despite it looks rightly done, but it was not rightly done. And we have told you how it can be rebutted. And we now say that another way of proving the validity of a will now is by leading affirmative evidence. So the people who were witnesses when the man made the will can come and testify that, yes, my lord, it is my signature that is there. I am one of the witnesses. So I can testify validly in this court that this man made this will out of his own consciousness and will. Also, there can be an evidence of the general habit and course of life of the testator. You can show that when the testator finishes making this will, he's the one that came by himself to my house and asked me to sign to this particular will. And even after signing to this particular will, the testator lived for additional 2 years, and he was well. So if he never really intended that will to be the way it is, he could have altered it, because a will is revocable during the lifetime of the testator. So if the testator did not alter the will or did not amend the will, and he stayed 2 years more after he had made the will, that in itself shows that he intended the will to be the way it was before he died. Now let us look at the ways of executing a will. How can the testator execute the will? There are three ways that a testator can execute his will. One of the ways is that he may sign the will in the presence of two witnesses who must be present at the same time. Remember, executing of a will means signing a will. Executing of a will means to sign a will. That is just what we mean by executing a will. So the executor can sign it or can execute it in the presence of two witnesses who must be present at the same time. Or he may pre-sign the will and acknowledge it in the presence of two witnesses that must be present at the same time. Meaning, he may sign the will at a date that is earlier than the date that the witnesses or attestators are signing. The only thing he will tell them, I am the one that signed. I signed this yesterday. That is, he will pre-sign. He may sign before the date that the attestators are signing. Or he may authorize another person to sign the will in his presence and the presence of those two witnesses who must be present at the same time. So he can tell somebody, okay, Obi, sign this will for me. Obi will be doing it, the testator will be looking at Obi doing it. And also the two witnesses will also be present when Obi is doing it on behalf of the testator. So these are the three ways that a testator can execute his will. Let me run it again. 1, he may execute the will in the presence of two witnesses. That is, he may sign the will in the presence of two witnesses. 2, he may pre-sign the will and acknowledge it in the presence of two witnesses. That is, signing it on an earlier date. Or he may delegate another person to sign the will on his behalf in his presence and in the presence of the two witnesses. So those are the ways of executing a will. And on that, we are going to be drawing the curtain on the topic Wills and Codicils I. And until we meet again, you take care of yourselves and have quite an awesome night rest.